In this issue, I discuss isoimmunization or alloimmunization of pregnancy, its grave complications, damage to the fetus, the parametric properties, differential diagnostics, and management algorithms. I start with the physiological buildup of the immune system in the fetus and then extend to perinatal disorders, including the RH sensitization, timing, and dosage of mother-to-fetus blood transfusions. The presented knowledge is based on my experience as an OBGYN doctor managing high-risk pregnancies, as well as my review of 359 published sources. I haven't cited or credited them all in my slides, as it was a technical challenge to list 359 sources in a limited space. I have cited only some, and if you claim that I do not give all authors credits, I am dismissing your claims up front and suggesting that you visit my book with the same coverage as that in those slides, a 216-page book that was published in 2016, in which I have cited and credited all 359 sources with their authorships. You can also read my disclaimer on slide 94. This lecture has 3 parts: clinical studies, legal studies, followed by review questions and answers, both medical and legal, a total of 28. In the legal section, I analyzed 6 cases as listed in chronological order. Based on those cases, I have informed advice for both prospective parties in malpractice actions litigating negligent management of the rhesus sensitization cases. My advice for the plaintiffs is to have timely collected data and facts, to be mindful of the time bar, and retain expert witnesses such as perinatologists, pathologists, obstetricians, pediatricians, neonatologists who are licensed and board certified by the state where the alleged damage has occurred and who can prove with the preponderance of the evidence in civil cases and beyond the reasonable doubt in criminal cases that the medical negligence in question had deviated from the standard of care, the type and level of care that an ordinary healthcare professional with the same training and experience would provide under similar circumstances in the same community, and that the alleged substandard level of care resulted in preventable and provable harm. Defendants, on the other hand, shall not rely on the plaintiff's assumption of risk, superseding evidence, or contributory negligence doctrines when it comes to the rhesus sensitization claims. Even where the trial court recognizes the flaws and faults on the part of plaintiffs and favors the defendants, such as healthcare providers, hospitals, or biopharma companies, who often present before the courts with already prepaid liability insurance coverage, in the majority of cases, the appellate courts reverse the lower court's decisions and remand the cases in favor of the suffered women and their stillborns or injured newborns. My advice for defendants is to be mindful of the fault jurisdiction, which varies from state to state. For example, the District of Columbia, as well as the states Alabama, Maryland, North Carolina, Virginia, and the territory of Northern Mariana Islands, practice the contributory negligence doctrine, whereby plaintiff may not recover if she contributed to the damage in any way. Any way. Whereas the states Alaska, Arizona, California, Florida, Kentucky, Louisiana, Missouri, Mississippi, New Mexico, New York, Rhode Island, Washington apply the pure comparative fault doctrine in medical malpractice suits, whereby the plaintiff's recovery is reduced by her share of fault. There are also modified comparative fault doctrines distinct with 50% or 51% rule bars. The former is called a proportionate responsibility doctrine, where the plaintiff's negligence offsets the defendant's liability, but the plaintiff cannot recover if she is found 50% or more at fault. This is practiced in the jurisdictions of Arkansas, American Samoa, Colorado, Georgia, Guam, Idaho, Kansas, Maine, Nebraska, North Dakota, Puerto Rico, Tennessee, U.S. Virgin Islands, and Utah. The 51% bar rule is practiced in these 23 jurisdictions. South Dakota is one unique state with rather qualitative measures of fault, so-called light gross negligence comparative fault jurisdiction, where plaintiff may only recover if she displayed slight negligence and the other party displayed gross negligence. But again, in the majority of cases, the appellate courts do not like impugning the plaintiff, usually the women, for their grave losses from the poorly managed pregnancies. Defendants must also consider that the courts distinguish the difference between the avoidable consequences and contributory negligence. In avoidable consequences, the injured party's negligence occurs after the defendant's wrongful act, whereas in contributory negligence, the injured party's flaw occurs before the defendant's wrongful act. So, after this brief introduction, I will let you read my slides on your own. Johann Sebastian Bach and Anna Magdalena Bach are in the background music. You can mute the music and pause the slides due course if you like. Goodbye.
you.